The defendant representative, where is he?
He's been caught, my lord. Mr. Abdiko.
Where is he? Let me see him. Let me see him. Mr. Abduduko, okay.
Good morning, my lord.
What's his position?
I'm the executive assistant to the managing director.
Okay. Very well. Though the matter is for judgment, the judgment is ready. I just want to let you know, I wouldn't know whether the claimant is aware that the first defendant filed a reply on point of law to your final written address, to the claimant final written address. Are you aware of that?
My lord, yes, we are aware.
Okay, and that has been deemed as having been adopted.
As God pleases, my lord.
Very well. So here is the judgment of the court.
As God pleases.
It is, please, you mute yourself, mute your phones, mute your systems, and just listen to the judgment of the court. I have with me online Honorable Justice Sanda Yawa. Milord Yawa is one of the newly appointed judges to the bench of the National Industrial Court of Nigeria. And Milord Yawa has been in private practice for a very long time, spanning up to 3 decades, and was a one-time member of the Investment and Securities Tribunal, and has actually acted as a chairman of that tribunal at a point in time. So Milord is bringing in all his wealth of experience to the bench of the National Industrial Court of Nigeria. And currently, Milord is going to be serving in the Lagos division of this court. I solicit the support of the members of the bar to Milord Honorable Justice Yewa. Milord Yewa, you are welcome.
Thank you very much, my lord.
Thank
you very much, my lord.
Very well. So let's go ahead with the judgment of the court. It is the claimant case that he was employed by the first defendant on contract for a 1-year period on the 1st of March 2021 to 28th of February 2022 as the chief operating officer. He averred that upon his resumption, the first defendant breached the terms and conditions of the contract of employment by willfully refusing to provide a suitable accommodation for him, as stated in his employment letter, and that he will stay at the company's guest house, but rather he was made to stay in an uninhabitable, dehumanizing room at the first defendant's corporate office, which led him to source for an alternative accommodation at top-rank luxury apartment. He averred further that the first defendant also failed to provide him with an official vehicle upon his resumption, consequent upon which he got an alternative, which is to hire a car for 23 working days, excluding weekends, amounting to about 460,000 naira, and that when the first defendant eventually provided him with an official car, it failed to make funds available for service and maintenance of the vehicle to the extent that he had to use his money to maintain it. He continued that the first defendant equally failed to provide him with the necessary tools for work, that he had to use his personal laptop. He further averred that the first defendant has been taking steps to use the agent of the second defendant to harass and intimidate him in a bid to stop him from exercising his right of lien on the Toyota Camry. It is against this backdrop that claimant took out a general form of complaint in this court on the 9th of May 2022 against the defendants claiming the following reliefs. 1, a declaration that all the benefits entitlement, including cost of expenses incurred by the claimant in the course of his contract of employment with the first defendant, being one concomitant with the claimant's contract of employment contained in the offer letter dated 27th day of January 2021, must be paid or liquidated to the claimant by the first defendant. B, an order directing the first defendant to pay forthwith to the claimant the sum of 6,992,975 naira, being the outstanding sum due, and or incurred by the claimant in the course or duration of the employment contract between the claimant and the first defendant, which said sum remain unpaid. B, a declaration that except and until the first defendant discharge herself, impose obligation under the employment contract entered into between the claimant and the first defendant, the purported termination of the employment contract between parties cannot be said to be properly and effectively terminated. D, a declaration that the claimant is entitled to remain and exercise legal lien over the first defendant Toyota Camry 2018 with registration number MKA 865SC assigned to the claimant by the first defendant as the claimant's official vehicle until the defendant defray or liquidated her indebtedness to the claimant. E, an order restraining the first defendant from using the agent of the second defendant from waylaying, harassing, or intimidating the claimant in the bid to stop the claimant from exercising his right of lien on the Toyota Camry 2018 with registration number MKA 865SC. While responding to the claimant's claim, the first defendant filed a statement of defense where it averred that contrary to the claimant's claim in respect of accommodation, he was provided with a suitable, well-furnished, self-contained apartment at the first defendant guest house at number 9, TOS Benson, Utako District, Abuja, reserved for executive officers. But claimant abandoned the renovated apartment to source for an alternative accommodation, despite the fact that the said apartment was neither poor nor dehumanizing. It maintained that there was no any agreement between both parties, stating that it would pay for the claimant's hotel adventures. It further averred that upon claimant's appointment, he was offered a fully functional service healers, but he rejected it and insisted on a luxury vehicle instead, and in a quest to satisfy him, a fully serviced Toyota Camry 2018 model was provided for him, and the said vehicle has been in his possession since then, even after the expiration of his contract. It noted that there was no any agreement between them to pay for a car hire for the claimant, that the claimant requested for the sum of 41,000 naira and 36,000 naira respectively for car servicing and change of tires, which was promptly paid, and subsequently it never received any request for repair or maintenance of the said vehicle from the claimant. It further averred that the claimant, upon his assumption as the COO, requested for a laptop, which it obliged him and handed him a brand new laptop for his use, but he locked it in his drawer and never used it, noting that there was never an agreement with the claimant for him to lease a laptop. Stated that it is not indebted to the claimant in a sum of 6,992,975 naira or any amount whatsoever. It further averred that apart from letter of demand sent to the claimant solicitor, the counterclaimant in this the counterclaim in this suit, it has not taken any steps to recover the vehicle. By way of a counterclaim, the first defendant averred that while the claimant was still in employment, he gave the claimant the sum of 5,500,000 naira deposit for a review of public-private partnership model with the Federal Ministry of Water Resources, but he failed to do it within the stipulated given time. It also averred that the claimant was paid the sum of 124,270 naira to produce business cards, ID cards, and layers for management staff, but he neither did it nor refunded the said money. It equally averred that the claimant was given the sum of 803,520 naira to subscribe for official email accounts for the MD and other management staff, but he also failed to carry out the instruction and also failed to refund the said money. It went further to state that the claimant was instructed to purchase carpets, noting that he mistakenly made a duplicate payment of 148,000 naira, but failed to refund the balance of 74,000 naira. Thus counterclaimed from the claimant the total sum of 6,377,520 naira, 6,377,520 naira, representing the outstanding sum due from jobs not carried out by the claimant during the period of his employment. It stated that the claimant failed to return the Toyota Camry in his possession. As such, it counterclaimed the sum of 20,000 naira per day for unlawful detention of the said vehicle. In response to the first defendant's counterclaim, the claimant contended that he effectively delivered the PPP agreement and model review mandate by submitting the business and financial model as a template without data, and he did not reject the document that he submitted. He also contended that contrary to the first defendant claim, the business card was produced and distributed accordingly, except for that of the management staff, due to the fact that the designation of some of the sales staff was not confirmed by the board of directors. Further contended that the payment of 803,520 naira was a refund to him for the 1-year Google subscription. He asserted that in respect of the double payment for the purchase of carpet, that he was not aware of any duplicate payment, as it was never brought to his knowledge. On the second day of May 2023, claimant opened his case and testified for himself as CW by adopting his witness statement on oath as his oral evidence in court. He tendered documents admitted and marked as Exhibit B to B17 and was cross-examined by the first defense counsel. In continuation of trial, the first defendant also called 2 witnesses, one Abdul Mutalib Diko, an executive assistant to the managing director of the first defendant, was called as DW1. He equally adopted his witness statement on oath and tendered documents admitted and marked on record as Exhibit D to D12, and was cross-examined by the learned claimant counsel. DW2, one Ibrahim Abdullahi, also testified for the first defendant by adopting his sworn deposition and was equally cross-examined by the claimant counsel. The first defendant thereafter closed its case, and the matter was adjourned for adoption of final addresses. Parties adopted filed their final written addresses, adopted same on record. I will now go on to the decision of the court. Upon a careful consideration of the processes filed by parties, arguments of counsel and authorities relied upon, it is in my respectful view that the issues for the just determination of this suit are: 1, whether claimant on the preponderance of evidence has proven that is entitled to the relief sought, and 2, whether the defendant counterclaimant is entitled to its counterclaim. By way of preliminary, let me address the contention between parties in their respective addresses as to the admissibility of some documents tendered in this matter. Claimant, by paragraphs 3.0 of his final written address, objected to the admissibility of Exhibit D, which is pictures, on the basis of Section 84 of the Evidence Act. Ordinarily, the law is clear that it remains a cardinal rule of evidence and practice in civil and criminal cases that an objection to the admissibility of a document sought to be tendered in evidence is immediately taken when the document is offered in evidence. It is part of the inviolate rule that where objection has not been raised by the opposing party to the reception in evidence of the document will be admitted, and the opposing party cannot afterward be heard except where the law specifically renders the document inadmissible. To complain about its reception in evidence, see the case of Terry Holdings Limited and Heritage Banking Company Limited, citation captured. The case of Akojomo and another, and a com and order, citation captured. John and State, citation provided. Ibori and Agbi and order, citation provided. Fatumbi and Olanloye, citation equally provided. The letter claimant counsel of Ateru Esquire, on the 3rd May 2023, when the document was tendered in evidence, failed to object to the admissibility of the said document. He only stated in his words, I quote, "We discovered some of the documents were not front-loaded. We reserved our right to address the court in our final written address." His objection above was never as to one of the documents being computer generated, but that some documents were not front-loaded, which is different from the objection they are now raising in their final written address to Exhibit D being computer-generated evidence. This cannot mean that learned counsel had objected to the admissibility of Exhibit D at the time it was tendered. However, the court is under a duty to admit only admissible evidence whether the opposing party objects or not. See the case of Benjamin and Kalio, citation provided. Shitu and Bashawe, citation equally provided. It is firmly settled that photographs under the Evidence Act are in the nature of secondary evidence, and to be admissible, the negatives must be tendered along with it. See the case of Ukman and another, and cross lines limited and another citation provided. However, in the age of digital photography, where anyone can use a smartphone to snap pictures and where pictures are stored electronically, it becomes necessary for the photographer or the one who snapped or took the pictures by any means to testify as to the process. See the case of Alhaji Ishaku Yakubu Enterprise Limited versus Teru, citation captured. The case of Musa and the state citation equally captured. This may be done either through oral evidence or by the person signing the certificate of compliance in line with Section 84 of the Evidence Act, notwithstanding a computer-generated document ought to be accompanied by a certificate of compliance to be admissible. See Umar and another inquiry and order citation provided. Leonard Defense Counsel had, in response to this in his reply address, submitted that the defendant did file a certificate of compliance along with its record. From the records of court, specifically at page 137 of the record of this court, the first defendant did file a certificate of compliance signed by one Abdul Mutalib Diko, DW1 in this case, who stated that the pictures were part of files stored on the defendant's computer, which he printed out. It is clear from the said certificate of compliance that the pictures are computer-generated evidence having been said to have been printed from the information stored on the computer of the first defendant. Assuming there was even no certificate of compliance, the said pictures are not rendered inadmissible by all means, but on the fulfillment of some preconditions which are contained in Section 84. I say so in view of the fact that the court per Judge Will, JCA, in the case of Oku and Trust Bond Mortgage Bank PLC, paragraph A, held us, and I quote, I've also looked at the succinct provisions of Section 84 of the Evidence Act 2011, which in my finding does not render any document by itself to be inadmissible in any event in law, but merely made provisions for conditions amounting to proper foundation for the admissibility of computer-generated documents, such as Exhibit 8B, B3, in evidence in a court of law, unquote. Thus, the pictures are not generally inadmissible, or secondary evidence that are admissible on the fulfillment of the preconditions listed in Section 84 of the Evidence Act. In the case of First Land Bank and Craft citation provided, Akash JCA, later GSC, now retired, held us, and I quote, if a party acquiesces on the admissibility of a document on the fulfillment of any precondition, he cannot be heard that the conditions precedent was not fulfilled before it was admitted. It is only documents which are inadmissible under any circumstance that can be expunged on appeal if no objection was taken on its admissibility, unquote. See also the case of Olukade and Alade citation provided. The effect of this is that where the evidence is one which is by law admissible under certain conditions and the opposite party failed to object to its admissibility based on failure to fulfill the preconditions when it was being tendered, and by implication consented to its admissibility, although the conditions precedent have not been shown to have been met, it cannot be allowed to raise the objection later. Therefore, even if the said certificate of compliance was not filed, the mere fact that the claimant did not raise this objection when the pictures were sought to be tendered, but only raised objection on the fact that some documents were not front-loaded, has deprived them the right to raise such objection at the stage of their final written address. It is in the light of the above that I discountenance the objection of the claimant to Exhibit D. It is equally the contention of the claimant in his final written address that Exhibit D1, which is the Zenith Bank Statement of Account, was neither pleaded nor front-loaded and thus not admissible. As reasoned supra, Leonard Claimant's counsel had raised the objection on the fact that some documents were not front-loaded during trial, though he was not specific which of the document he was referring to. He thereafter reserved his right to address the court in his final address on that. Let me address the assertion that Leonard Claimant counsel kept making as regards his objection to some of the documents, especially Exhibit D1, D2, and D4, i.e., Statement of Account of the first defendant payment voucher of the sum of 810,000 naira, receipt and payment vouchers. that they were not pleaded in the statement on oath of DW1 in paragraph 3.6 and 3.10. These assertions were also contended by Leonard Defense Counsel in paragraph 2.8 of his reply address, that pleadings is different from evidence and facts not usually pleaded in written statement on oath, but in pleadings. It is merely stating the obvious for me to say that a written statement on oath is a witness statement in which the deponent tells the story of the evidence on the fact as pleaded by the party on whose behalf he's testifying. It is different from pleadings. The front-loaded deposition on oath of a witness in support of his pleadings constitutes his evidence in chief in the proceedings, and thus is clearly different from the statement of defense, which is the pleadings. The requirements of the law that a piece of evidence must be pleaded to be admissible does not refer to statement on oath. Rather, it refers to it being pleaded in either the statement of facts or claim or statement of defense, which represent the pleadings of a party. Therefore, it was a misconception on the part of Leonard Counsel for the claimant to object to admissibility of documents on the erroneous ground that they were not pleaded in the statement on oath of a witness. Be that as it may, Leonard Defense Counsel in paragraph 2.4 of his reply address contended that the statement of account was pleaded in paragraphs 7, 31, 33, 35, and 36 of the statement of defense and counterclaim. It needs to be stated that once a piece of evidence is considered relevant and admissible, it will be admitted. See the case of Owaka and RSHPDA citation captured, and the case of Oloma and Akpe citation equally captured. It must also be added that the mere fact that a document or piece of evidence was not front-loaded will not render it inadmissible, especially where it was pleaded and alluded to in the pleadings. See the case of Abubakar and INEC citation provided, Okboru and Oduaha citation equally provided. Thus, the fact that SBD1 was not front-loaded should not ordinarily affect its admissibility. The law, therefore, is that there are three main criteria that govern admissibility of documents. They are: 1, whether the document is pleaded; 2, whether it is relevant to the inquiry being tried by the court; and 3, whether it is admissible in law. See the case of Ogunsanwo and Asu and other citation captured. Let me now consider the stance of the first defendant above in his reply at the address that the said SBD1 was pleaded. I perused the whole of the statement of defense of the first defendant, and I find that while paragraph 7 talks about the books of account of the first defendant and electronic debit alerts, which may not be the statement of account per se, paragraphs 31, 33, 35, and 36 thereof referred to statement of account of the first defendant, evidencing different alert payments made to claimant. The said paragraphs did not specifically refer to the Zenith Bank statement of account covering the periods in SBD1. In fact, there is also another statement of account also tendered by the first defendant, in this case as SBD 12. I bear in mind the standing position of the law that documents need not be specifically pleaded. It is sufficient if facts contained in the documents are pleaded or alluded to in the pleadings. See Heritage Bank PLC and Ifeanyi Oyeako and another citation captured, Access Bank PLC and Abuja citation equally provided. However, in this instance, it is worthy of note that the amounts pleaded in the above paragraphs of the statement of defense and counterclaim in respect of which the statement of account referred to therein was referred to or alluded are not the same as the one covered by SBD1, which is the bone of contention. In fact, none of the amounts in SBD1 was pleaded in the statement of defense and counterclaim. In the case of Abubakar and Chuk citation provided, where to be GSC of blessed memory held entirely as follows, I quote: in other words, a document which is consistent with the pleadings is admissible if the document is admissible in law, unquote. SBD1 failed to meet one of the criteria for admissibility, which is that it was not pleaded or facts contained in it were not pleaded or alluded to in the pleadings of the first defendant. Besides, Section 84 of the Evidence Act allows for the admissibility of a statement contained in the document produced by a computer. Banking practices having emerged from the days of parchment and weighty paper to now modern entries of account books or records and statement to computer or electronic records, it follows, therefore, that all statements of account emanating from banks these days are invariably computer generated. More so, the Apex Court's decision in the case of Attorney General of the Federation and Anu Ebunwa citation captured, Gwomiju GSC held that it is the algorithm or data imputed by bank officer into the bank's database that generates the various information on the statement of account of a customer. Thus, the bank statement is a computer-generated document which has to be certified by the officer who ensures that no one illegally or without authorization tampered with the source data as officially imputed in the computer. Also, the certification must include that the computer was operational or in good working order when the document was generated. It is thus clear that a statement of account is more of a computer-generated evidence other than a mere entry in the banker's book. As stated earlier, the first defendant did file a certificate of compliance signed by DW1, and therein he listed a statement of account of the first defendant as part of the documents he printed from the first defendant computer. DW1, who made the statement certifying the correctness of the information, and the computer from which he printed the statement is not an officer of the bank, which the Apex Court stated in Attorney General of the Federation and Anu Ebunwa's case supra to be the proper person to certify a bank statement of account. Thus, the fact that a certificate of compliance was filed in support of the statement of account will not give the said statement of account a symbol of admissibility, especially in this instance, where sums covered by the statement of accounts were never pleaded in the statement of defense or even the reply to defense to counterclaim of the first defendant to make them relevant to the facts of this case. The law is settled beyond peradventure that where a court, as in this instance, case, inadvertently admits inadmissible evidence, the trial court is under a duty to expunge it in the course of a judgment and not to act on it. See Momodu and Ibrahim citation captured, Royok Nigeria Limited and AG and CJ, Sokoto State and another citation provided. Thus, as D1 for the above reason is thus not relevant and in itself inadmissible, but was admitted and inadvertently by this court. It is at this stage that it is expunged from the record of this court. The claimant also objected to the admissibility of Exhibit D2, which is a payment voucher, and D4, which are receipts, on the ground that they are secondary copies of private documents and no foundation was laid for the whereabouts of their original copies, and they were never pleaded in the witness statement on oath. I've addressed the issue of the propriety of the objection on failure to plea a document in the statement on oath earlier. Howbeit, Learned Defense Counsel on behalf of the first defendant had submitted bid paragraph 2.7 of his reply address that the original copies of these documents were all tendered. He also submitted bid paragraph 2.9 of his reply address that the facts relating to provision of executive accommodation, its renovation, and provision of laptop and official vehicle to claimant were all pleaded by the defendants. First and foremost, as stated supra in this judgment, the only objection claimant raised to the exhibit tendered by the defendants during trial was that some of the documents were not front-loaded. No objection was ever raised to any of the documents not being pleaded or that they are secondary evidence of private document with no proper foundation laid for the whereabouts of the original. It is too late in the day, therefore, for claimant to be raising such objections now in his address. Besides, it is a long-standing position of the law that a court is entitled to look at the record in its possession and make use of information therein in the overall interest of justice of the case. See Nigeria Engineering Works Limited and NCS Board and others citation captured, Womiloju and Anibire citation provided, Agbari and Nimra citation captured. Such record of the court takes preeminence over parties or their lawyers' account, as the record binds the court on one hand and the parties on the other hand as to what transpired during proceeding. See the cases of Access Bank PLC and Sijuade citation provided, Wamzami and another, and Salisu and other citation provided, Soma and others, and FHA citation equally provided. I've gone through the record of the court and I find as submitted by Learned Defense Counsel that the documents that were tendered as SB D2 and D4 are actually original copies, which are primary evidence and not secondary evidence that requires laying of foundation before tendering them. I do not know what informed the position of Learned Claimant Counsel that the said exhibit as secondary evidence that the first defendant ought to lay proper foundation as to the whereabouts of their original. Learned Counsel also objected to the admissibility of exhibit D5, D6, and D7 on the ground that they were not pleaded in any paragraph or statement on oath of DW1 or DW2. First, as reasons supra, documents are not pleaded in written statement on oath of witnesses, but in pleadings, as I've stated earlier in this judgment. Again, the first defendant did not plead that it gave claimant a laptop and that claimant was given the sum of 124,270 naira to produce business cards. As reason supra, it is not compulsory for a document to be specifically pleaded. It is sufficient if facts in it are pleaded. Since the first defendant pleaded these facts, they are well within limit to tender exhibits D5 and D6. Secondly, as regards exhibit D7, which is a letter dated 7th April 2022, as against 17th August 2022, referred to in paragraph 3.17 of the claimant's final written address titled, quote, re-expiration of employment contract as Chief Operation Officer of GAMS and Abel Consortiums, unquote, was clearly pleaded, read paragraph 26 of the first defendant's statement of defense. The said objection is misconceived and thus discountenanced. The claimant in this suit sought the grant of declaratory reliefs. It has been held in plethora of judicial authorities that in a claim for declaratory reliefs, as in the instant case, claimant must succeed on the strength of his own case and not on the weakness of the defendant's case. Claimant will not be entitled to judgment even on admission by the defendant. It is the duty of the claimant to first prove the existence or non-existence of what he asserted by relevant, admissible, and credible evidence. There's no doubt from the fact of this case, and as agreed by parties, that the employment relationship that existed between parties was one of master-servant, where the terms and conditions of employment are reduced into writing. It is the claimant's claim that the first defendant is indebted to him in the total sum of 6,992,975 naira. According to claimant, the contract entered into between parties, that is Exhibit B, provides for provision of executive accommodation in the company's guest house as the chief operating officer, that is the COO, which the first defendant failed to do. Instead, they asked him to take up a one-room apartment at the first defendant's corporate office, and which situation compelled him to source for an alternative accommodation at top-ranked luxury apartment between the 1st of March 2021 to 28th of February 2022. The first defendant, in response, read paragraphs 5 to 8 of his statement of defense, stated that claimant was provided with well-furnished, self-contained apartment in his guest house, but which claimant rejected and requested that the work area be redesigned to his specification, which was done at the first defendant's expense, but claimant still abandoned and renovated the renovated accommodation, despite the fact that his demands have been met to specifications. The first defendant in support relied on Exhibit D. Claimant, in response, read paragraphs 4 to 8 of his reply to the statement of defense, stated that the accommodation provided in the office of the claimant could not have been the executive accommodation provided in Exhibit B, and this, amongst other things, were the reasons he rejected it, because same was in flagrant breach of his contract of employment. He also contended that a request for modification was in respect of his office space and not the official accommodation. He maintained that the room is not the type of the accommodation specified in his contract, that is in Exhibit B. It is Hornbook law that where the terms of contract, as in this instance, are in writing, parties are bound by the express terms of their contract. See the cases of Fort Oil PLC and Ogungbe Mile citation captured, the case of LD Corn Nigeria Limited and UBA PLC, citation equally provided. A court of law must be circumspect to respect the sanctity of the agreement reached by parties. As such, it must not make a contract for them or rewrite the one they have already made for themselves or read into the contract what is not contained therein. See the cases of Julius Berger, Nigeria PLC, and another versus Toki Rainbow Community Bank Limited citation provided, Adeboye and Sky Bank citation provided, Babatunde and Bank of the North Limited citation provided, SC Co Limited and NBC citation equally provided. The duty of the court in such instance is to interpret the terms of the contract of parties and give effect to it. See the case of Sahara Energy Resources Limited and Mrs. Olawumi Oyibola citation provided, the case of the same of Nigeria Limited and Kwara State Government and others citation captured, Omega Bank Nigeria PLC versus OBC Limited citation equally captured. The court in interpreting the terms of contract between parties must give the words their plain, ordinary, and natural meaning where the words used are clear and unambiguous. See the case of Omoyeni and CBN and other citation provided, Ibama and SPDC Nigeria Limited citation captured. The court in determining the rights and obligation of parties under the contract must confine itself to the terms of service between the parties, which provides for their rights and obligations. Thus, no court should look beyond those terms and conditions as stipulated in the document in determining the rights and obligation of parties to the agreement. It is in view of this that this court will consider the dictates and the contents of the contractual agreement as contained in Exhibit B. Exhibit B stipulates those as regards the terms and conditions of service. I quote, tenure, 1 year, full-time, renewable contract, subject to satisfactory performance of project extension imperatives. Place of assignment to be primarily based in Abuja. However, to travel the operational site and outside Abuja will be necessary from time to time. Performance management guided by agreed deliverables, targets, and KPIs, including above reference responsibilities. Remuneration, salary, 12 million naira per annum, gross, housing, executive accommodation in company's guest house, official vehicle, and official company service work vehicle will be provided. Resource requirement, human and other material resources to be discussed, unquote. I peruse Exhibits B16 and Exhibit D, and I find without doubt that the accommodation offered claimant was at the head office of the first defendant, TOS Benson Crescent in Utaku. In fact, DW1 confirmed this under cross-examination that the head office was an executive apartment converted to an office space, and that one of the rooms therein was what was converted to an executive apartment for claimant, and that apart from the room, there was a kitchen and a parlor and claimant's own private office. However, I also bear in mind that Exhibit B, which states that claimant will be given an executive accommodation in the guest house of the first defendant, did not give specifics as to what will be an executive accommodation, neither did it state the address of the said guest house. I'm, however, of the view. I bear in mind the testimony in paragraph 8. In paragraph 8 of the written address of I bear in mind claimant's testimony in paragraph 8 of his written statement on oath of 9th of May, 2022, that he was compelled to stay in top-rank luxury apartment with the view that the first defendant will refund same the moment it is able to source for executive accommodation for him. It is my view that Exhibit B, being documentary in nature, is therefore permanent and cannot be varied by parole evidence. When therefore, as it is observed in the instant case, there is nothing contained in Exhibit B that claimant can stay in an hotel apartment at the expense of the first defendant, same shall therefore not be allowed to be read into Exhibit B or to alter it. See the case of Balio Nigeria Limited and Navcon Nigeria Limited citation captured, Atra Industries Nigeria Limited and Nigeria Bank of Commerce and Industry citation captured, UBN Limited and Saks Nigeria Limited citation provided, Royal Exchange Nigeria Limited and Aswani Textiles Industries Limited citation captured. The court, however, recognizes that an agreement may be varied by another agreement, assuming the accommodation given to claimant is unsatisfactory and does not meet his state standard of quote and unquote executive accommodation, and he intends to instead live in a comfortable commercial apartment or hotel or accommodation at the expense of the first defendant, claimant should have requested that the terms in Exhibit B as it relates to his accommodation should be varied by the replacement of executive accommodation in company's guest house with accommodation in a commercial apartment or hotel or accommodation at the expense of the first defendant. This was not done in this case. Claimant decided on his own volition to go stay in the hotel. There is nothing placed before this court to show that the first defendant committed itself to the payment of the hotel accommodation or agree that it will reimburse claimant for such expenses. In fact, the first defendant, read paragraph 12 of its statement of defense, contended that there is no term in the contract of employment or any other agreement whatsoever between the first defendant and the claimant in which the first defendant agreed to pay for the claimant's hotel adventures. These facts were also reiterated in paragraph 14 of DW1 statement on oath. Learned Claimant Counsel never cross-examined DW1 on this material point, that there is no term in the contract of employment or any other agreement whatsoever between the parties and the claimant, between the first defendant and the claimant in which the first defendant agreed to pay for the claimant's hotel adventures. It is right that where a witness is not cross-examined on a crucial and material point, the only conclusion is that the adverse party who ought to have cross-examined the witness accept the evidence of the witness as true. See the case of Uluwale and Olatunji citation captured, Gambo and Issa and another citation provided. As the DW1 was not cross-examined on his robust assertion that there is no term in the contract of employment or any other agreement whatsoever between the first defendant and the claimant in which the first defendant agreed to pay for the claimant hotel, it means that the respondents accepted the evidence of these defense witnesses. Besides, the law is clear that contract of employment is equally governed by regular tenets of contract. It is elementary that where one of the parties to a contract defaults in the performance of any part of the contract, the other party has one of two options open to him, which are one, to regard the contract as still subsisting and see for specific performance of the contract, or for an injunction where the obligation is a negative one, or two, to regard the contract as an end and sue for damages for the breach of it. See the cases of Malik and Kaduna Furniture and Carpets Company Limited citation captured, and Naeze and Anyaso citation provided. In the instant case, claimant did not do any of the two options, but instead continued with the contract and even lodged himself in an hotel accommodation outside the terms of the contract and allowed the contract to run till the end. But is now after the lapse of the contract by a flution of time, and there is no renewal, now suing to claim the cost of his hotel accommodation when there is nothing before the court to show that the first defendant consent was sought, obtained, granted, and agreed to be bound to pay. In fact, there is nothing before this court to show that prior to the expiration of the contract, claimant even demanded for the cost of his hotel accommodation from the first defendant, which is claiming in this case, and in support of which he tendered receipt of payment for the hotel accommodation bid as with B15. I'm mindful of the contents of Exhibit B4, which claimant had pleaded in paragraph 13 of his reply to statement of defense. I've read the said exhibit, and I find that claimant, in the said letter addressed to one director in the first defendant at page 3 thereof, item 5, only complained that the accommodation given him was not befitting, and that he has sought for alternative accommodation, and that the value of the proper accommodation be monetized and amortized into his monthly salary to the end of his tenure. In his words, I quote, "Part of the terms and conditions of my employment was that I'm provided with accommodation, given that the board is aware that I have a family and also that my tenure is 1 year full-time renewable contract, subject to satisfactory performance of project extension imperatives. I was shocked to see that I was given a self-contained room directly opposite the office I operate from at the GAMS and Abel project office. There's no way I could have resided in such an accommodation full-time, whereby my family could visit me. I have therefore been forced to look for other means of accommodation for the past 7 months of my work as COO. The accommodation initially allocated has since been utilized by the MD for other official purposes. I therefore request that this key provision, which is part of the terms and conditions of my employment, be addressed. I suggest that given that I have 5 months to the end of my tenure, the proper accommodation provision be valued, monetized, prorated, or amortized into my monthly salary to the end of my tenure, unquote. It is clear from the above that claimant never even indicated the kind of alternative accommodation he sought. Talk more of informing the first defendant that he was staying in top-ranked luxury apartment, which cost him once the first defendant to be bound to pay. He also clearly never asked that the cost of his alternative accommodation at top-ranked luxury apartment be paid to him. Instead, he asked that since he had just 5 months to the end of his contract, that the proper accommodation provision be valued, monetized, prorated, or amortized into his monthly salary to the end of his contract. Thus, the issue of the need for the first defendant to be bound to refund claimant for the payment of accommodation expenses at top-ranked luxury apartment is just coming up for the first time before this court. Worse still, claimant in this case did not even plead or stay in evidence what the total cost of his stay in top-ranked luxury apartment that he wants the first defendant to pay was. I'm not unmindful of the fact that claimant has stated supra exhibited the receipt of his payments in SBP 15. It is non-settled position of the law that a judge is not permitted to embark on an inquisitorial examination of documents outside the courtroom. Worse still, he's not allowed to act on what he discovered in such a document in relation to an issue when that was not supported by evidence or pleaded. If there is a gap or omission, it is not the duty of this court to fill that yawning gap. This is because the court is an impartial arbiter and its duty is not inquisitorial. See the case of Umishori and another, and Aregbe Shola and others citation captured, Magaji and Nigerian Army citation provided, Jalingo and Iyame citation provided. Thus, it is not even this court's duty to start adding up. Just a minute, please. Thus, it is not even this court's duty to start adding up the sums in the receipts issued by top-ranked luxury apartment to find out how much the total cost of claimant's accommodation in their apartment for 1 year cost. Besides, claimant who would want this court to believe that he stayed in the apartment for 1 year spanning from the 1st of March 2021 to 28th of February 2022 only tendered receipt, which covers only March to August 2021. This court cannot speculate on the rest of the month since they are not in evidence and cannot manufacture evidence for the rest of the months or period to help claimant's case. See the case of Cardi Ventures Limited and Honorable Minister of FCT and other citation captured. This court cannot speculate on this fact, as a court of law cannot speculate on anything. See INEC and People's Redemption Party and other citation captured, Fayemi and Oni citation provided, Ejizie and Anua citation captured. In fact, the court did drive home this point in the case of Adisa and the state citation provided. Toby JSC, as he then was, Toby JCA, as he then was, emphatically stated as follows, I quote, "Judges are not allowed by the law to speculate or conjecture on possible facts. They do not have such jurisdiction. That is wrong. The only jurisdiction they have is to make use of the court facts of the case as presented by parties in open court and use them. They cannot do more. They cannot even do less. Such is the job of a judge. After all, a judge is not a metaphysician. He's not even a soothsayer. He's simply a judge of law," unquote. It is also claimant's claim that the first defendant failed to provide him with an official vehicle. Immediately he assumed office as the COO, which caused him to hire a vehicle for 23 working days, excluding weekends in March 2021, at the rate of 460,000 naira. In support, he relied on receipt of payment, which is part of a bundle of documents marked as B15. The first defendant, in response, by paragraphs 13 to 14 of his statement of defense, contended that claimant upon his appointment was given a fully functional service vehicle, Helios, but he rejected it and insisted on a luxury vehicle, and which request it worked on by sourcing and providing claimant with a fully serviced Toyota Camry 2018 model with registration number MKE865ST, and which car is still in possession of claimant even after repeated demands upon the termination of his contract. Noteworthy is the fact that the Toyota Camry has been retrieved from the claimant during the pendency of this suit, specifically on the 6th of January 2023, by an order of this court granted without objection upon a motion or notice filed by the first defendant. The first defendant contended further, vid paragraph 15, that there was no agreement whatsoever between it and claimant to pay for a hired vehicle. It is worthy of note that claimant in his reply to the statement of defense did not specifically respond to the averment of the first defendant in paragraphs 13 and 14 of his statement of defense that claimant at first was provided with a Helios vehicle, which he rejected and insisted on a luxury one, which was subsequently provided for him. It is a settled principle of law that every allegation of facts in the pleading must be met horizontally and not just evasively, and as such, any fact not denied is deemed admitted. See the case of Ubula Traditional Council and Orders versus Estate of the late Benjamin Wasway and Orders citation captured, Buhari and INEC and Orders citation provided. Besides, such new facts raised in the statement of defense of the first defendant as per offering claimant a Helios, which he rejected, ought to be responded to by the claimant specifically. Otherwise, he is deemed to have admitted them and cannot lead evidence in rebuttal of such facts. Such admitted facts need no proof, and the court is expected to act thereon. See the case of Gite and Ubulo, citation captured, and the case of Atanda and Iliasu, citation provided. In fact, this fact was much admitted by claimant himself under cross-examination on the 2nd day of May 2023 when he answered those, I quote, "I was provided a vehicle 1 month after I resumed office in breach of my contract. I was offered a Toyota Helios, which is an operational vehicle. I rejected the Helios and requested for a status vehicle," unquote. Thus, according to claimant, he was not given an official vehicle until after a month. Before then, he personally hired a car, which cost he now wants the first defendant to pay. It is clear from the state of pleadings and claimant's admission under cross-examination that claimant was offered a Helios car, which he, on his own volition, rejected and asked for another, which was provided him after a month, and pending the provision of a said official car, claimant hired a vehicle to transport him to office as evidenced by Exhibit B15. Exhibit B, which is the contract document, merely provided that, quote, "official vehicle, an official company service work vehicle will be provided," unquote. There was nowhere specification was given to the type of car that claimant will be given. It is only logical to make a finding that the first defendant did not breach the term of the contract by giving the claimant a Toyota Helios, which claimant rejected, and to ask for what he termed quote and unquote status vehicle under cross-examination, and which the first defendant graciously provided him. Now, if it took the first defendant 1 month to get an alternative car in order to satisfy claimant's request, I do not think the first defendant should be held liable to pay the cost of car hire for the 1 month, a situation which claimant specifically put himself because of his own personal taste. Claimant wrongly rejected the Toyota Helios given to him because the contract document did not say that a Toyota Helios is not an official vehicle, neither did it give specification as to what the official vehicle would be. He could have reasonably accepted the Toyota Helios pending the time the first defendant would provide him with a Toyota Camry, which was provided a month after. He brazenly rejected the Helios, which caused the first defendant to look for another vehicle for him, but he now wants the first defendant to be responsible for payment of the car hire service, which he voluntarily opted for, without the input or consent of the first defendant. This is where equity in its true sense comes in, or is brought through the inherent jurisdiction of this court of law vested in it by Section 6, subsection 6 of the Constitution of the Federal Republic of Nigeria 1999 as amended, as well as Section 13 of the National Industrial Court Act 2006. Admittedly, equity does not make the law. It is only there to aid the law, and it follows the law. Equity would not allow a man to take advantage of his own wrongdoing, as expressed in the Latin maxim, nolus commodium e pere protede injurius corpora, meaning no man can take advantage of his own wrong. See the case of Tonimus, Nigeria Limited, and Chibu, citation captured. Claimant caused the situation that made him to hire the car service, and this court would not allow him benefit from his own wrongdoing. To cause and orchestrate a scenario to benefit from a wrong not committed by the first defendant, who provided claimant with the Toyota Hilux and later a Toyota Camry as official vehicle, but which claimant rejected and instead hired the car without the consent or approval of the first defendant for the 1 month he was without official vehicle, is to call in aid equity where the law may be rigid and offensive. Compelling the first defendant to pay or refund claimant for the car hire service is tantamount to allowing claimant to benefit from his wrong, as I've stated earlier. This court will not lend its quick voice to such a wrongful act, and I so refuse to do so. It is equally claimant's claim that the first defendant failed to provide money for servicing the vehicle, and that he incurred the sum of 115,000 as cost of servicing the vehicle and replacement of spare parts over the period of 1 year. The first defendant, in response, by paragraphs 17 and 18 of the statement of defense urged that claimants requested for the sum of 41,000 and 36,000 naira respectively for car repairs and change, just a minute, and change of tires of the Toyota Camry, which was promptly paid to him on the 7th of June 2021 and 8th of May 2021 respectively, and that he did not receive any further requests from claimant for repair or maintenance of the said vehicle in the course of the employment, and it is the norm in the first defendants for employees to make such requests for the maintenance of resources attached to them. Claimant, in response to the above averment of the first defendant, that the first defendant has confirmed that it is its duty to service the said vehicle, which confirms claimant's claim, and which some claimed is the cost incurred for servicing the vehicle exclusive of the sum of 41,000 and 36,000 naira respectively stated in the first defendant's statement of defense. Claimant had relied on copies of receipt, which forms part of a bundle of documents in SBD B15. I peruse the said receipt, and I find that, just a minute, and I find that the sum of 115,000 for servicing and replacement of spare parts claimed by claimant is at variance with the sums covered by the receipts. In fact, throughout the whole of claimant's pleadings, there was nowhere he pleaded a particular sum he incurred in servicing the car, or particular sum he spent in replacing spare parts, or what particular spare parts he replaced, in order to show how he came by the quantum of the sum of 115,000 claimed as a total cost for servicing and replacements of spare parts. He did not also tie the specific receipt with his claim for servicing. He just tendered a bundle of receipts from different filling stations, which contained different sums. In the absence of an averment pleading the specific sum used in servicing and the sum used to replace spare parts in the said vehicle, the court cannot know how he came by the quantum of the sum claimed. I'm not oblivious to the fact that claimant tendered the receipt of payment for spare parts of car, which receipt is part of a bundle of documents marked as B15. As reasoned earlier, A judge is not allowed to embark on inquisitorial administration of justice, and where there is a gap or omission in the case of a party, it is not the duty of the court to fill that yawning gap. This is because the court is an impartial arbiter, and its duty is not inquisitorial, as I've stated severally. Thus, this court does not even have a business in speculating on making deductions on the exact amount of the money he allegedly expended, be the receipt from the sum of 115,000 naira claimed, to know how claimant came by the quantum of the sum. It is the duty of the claimant to show clearly by specific pleading how he came by the quantum of the sum claimed and support same with credible evidence. Again, it is noteworthy that from the state of pleadings above, it is clear that it is the duty of the first defendant to service claimant's official card. In fact, the content of Exhibit B lends credence to this because the said contract provides that, I quote, an official company service work vehicle will be provided, unquote. It is also clear from the state of pleadings that claimant did not deny receiving the sum of 41,000 and 36,000 naira respectively from the first defendant. He also did not deny the averments of the first defendant that he did not receive any other request from claimant as per the services of the said vehicle, and the norm in the first defendant is for employees to make such requests. There is no doubt, therefore, that the above facts require no further proof. In fact, DW1 under cross-examination by learned claimant counsel on the 16th of June 2023 clearly reiterated the fact that claimant never requested for any other money, and that if he did, he would have been paid. Now, the question that agitates the mind of this court is, assuming claimant even proved the said sum, can the first defendant be held liable where claimant has not denied that he did not make any further request from him as per servicing the vehicle, since it is the norm for employees to make such requests? The answer is obviously in the negative, because the first defendant cannot be held liable since claimant has failed to even do the needful by making such requests. Equity, it is said, helps the vigilant and not the indolent. A person who is indolent about his right cannot receive succor from a court of justice. Claimant also claims for the cost of renting his laptop to the first defendant for use because, according to him, he was not given necessary tools for work by the defendant, which caused him to use his laptop for the first defendant's work. And the cost of leasing his laptop per day at the rate of 2,000 naira for 23 days per month is 276,000 naira from March to August 2021. The first defendant read paragraphs 19 to 21 of the statement of defense averred that claimant, upon his resumption for work, requested for a laptop and he was given a new one, but he locked it away in his drawer and never used it, and that he was also provided with other necessary working tools for the discharge of his responsibilities, and he never requested for additional work tools. It maintained that there was no agreement between it and claimant, whether in the terms of employment or elsewhere, for claimant to leave his laptop for the benefit of the claimant. Claimant responded read paragraphs 17 to 20. Just a minute. Claimant, in its response, read paragraphs 17 to 20 of his reply to the first defendant's statement of defense, averred that he had requested for same, read an email, and that if the first defendant gave him as asserted, there should be an instrument of allocation or any document to prove that official laptop was allocated to him. He also further contended that the laptop referred to by the first defendant was a laptop procured for general office use and presentation during internal and external stakeholders' engagements, and that as the second most senior executive of the first defendant, he was not expected to be using a general purpose laptop, while other management staff were allocated laptops individually. He also maintained that the managing director and the board of directors were aware of the fact that he was not given an official laptop to work with. Claimant relied on Exhibit B4 and B7. As stated earlier in this judgment, a court in determining the rights and obligations of parties under the contract must confine itself to the terms of the contract of service between the parties, which provides for their rights and obligations. Exhibit B embodies the contract between claimant and the first defendant. Exhibit B reads thus as regards provision of resources for work, I quote, resource requirement, human and other material resources to be discussed, unquote. There's no document before this court to show that the claimant and the first defendant specifically discussed and agreed that claimant will be given personal official laptop or that he had the right to personal official laptop. Even though Exhibit B4 and B7 clearly show that claimant was not given a personal official laptop contrary to the assertion of the first defendant. There's nothing in Exhibit B or elsewhere to support claimant's claim that he was entitled to personal official laptop. Claimant did not also place any cogent and reliable evidence before this court to show that other management staff of the first defendant, as he asserted, were each allotted a personal laptop. Claimant, in this case, in his reply to statement of defense, had averred that the laptop the first defendant was referring to that he gave to him was an all-purpose laptop and one for presentation during internal and external stakeholders' engagements, and that as the second most senior executive of the first defendant, he was not expected to be using a general-purpose laptop. It is therefore clear that notwithstanding that claimant was not given a personal official laptop, he still had access to one, which he called all-purpose general laptop. And he has not said that the said laptop was not functional. Claimant claimed that he used his personal laptop for the first defendant and thus is entitled to claim costs for leasing his laptop. If I may ask, is there any agreement between parties for claimant to lease his personal laptop for the work of the first defendant at the rate at which claimant is claiming? Obviously, there is none before this court. In fact, in either Exhibit B4 or B7, there was nowhere claimant during the pendency of the employment relationship intimated the first defendant of the alleged leasing or rentage of his personal laptop at the rate in which he is claiming in this case. Claimant also claimed for interest, which according to him assessed at 15,000 per month. In fact, claimant has not even shown this court how he came by the monthly interest of 15,000, which is claiming in this court. Exhibit B, which is the contract, did not make provision for such interest sum. Clearly, this assessed interest is not based on the agreement of parties. Claimant has not alleged that charging such interest was based on mercantile custom or the usual course of business in the first defendant or the industry where the first defendant runs its business. It is mandatory that the basis of such computation be explained so as to determine whether the interest is liquidated or unliquidated. In the case of Just Steel Rolling Company Limited and Benin Steel Nigeria Limited citation capture, the court held those. For a claim of interest to properly exist for determination in a court of law, it must be stated in the endorsement of the claims to the writ of a summons or in the statement of claim also. The grounds upon which the claim of interest is based must be stated whether the claim is based on contract or statute. Consequently, before a person can succeed on a claim of interest, he must endorse the claim on the writ and also plead facts which will show that he is entitled to such interest. In the instant case, the respondent having sued under the undefended list must state in the endorsement of the claims to the writ of summons or in the affidavit whether the claim of interest is based on contract or statute and the grounds upon which the claim is based. Unquote. It smacks of bad faith, malice, and gold digging for an employee who is paid in millions as shown by SBB and who is expected to use his utmost best for the business of his employer to come to court, claim sums of money for lease or laptop because he used his personal laptop for the business of the employer when there was no such prior agreement with the employer and interest on sums claimed. He has not shown that such interest is envisaged under statute, agreement, or custom of trade. This court is a court of justice and equity, as I've stated earlier. Equity acts in personam. Equity acting in personam will not lend its support to any conduct that smacks of bad faith or fraud and which lacks conscience, malicious, or gold digging. See the case of Obo and another Nigeria Football League Limited and other citation captured. This court will not equally accede to such a claim. In view of all the reasons above, claimant has failed to justify that the first defendant is indebted to him by reason of failure to fulfill his obligation under the contract of employment. Thus, this court cannot grant his prayer in Relief A. Accordingly, Relief A fails in its entirety. Claimant by Relief B seeks an order directing the first defendant to pay him the sum of 6,992,975 naira, being the outstanding sum due and or incurred by him in the course or duration of the employment contract between him and the first defendant, which sum remains unpaid. This claim is no doubt a claim for special damages, which must be specifically pleaded with listed particularity and strictly proved. See the cases of Egypt's Air Limited and Ibrahim and another citation captured. Ajiba Tosho and RCC citation provided. British Airways and Atoyebi citation provided. Joseph and Abubakar citation provided. Claimant in this case claims for cost of accommodation at top rank luxury apartment. Cost of car, just a minute. Cost of car, hire service, cost of servicing and repairing his official car, cost of lease of his laptop, and the interest which, according to him, makes up the sum claimed in Relief B. As I've reasoned earlier in this judgment, claimant did not even plead the sum that represent the cost of his commercial accommodation at the said top-rank luxury apartment, and the receipt of payment tendered did not reflect the full period which he averred he used to stay in the said apartment. He also did not plead how he came by the quantum of a sum of 115,000 as I've stated earlier, claim for servicing and replacement of spare parts in his official vehicle. He also did not plead what particular spare part he replaced. The law does not give room for a court to speculate on issue of special damages and allocate value for alleged damages by resort to sentiment and gestures. Thus, where the party who suffered the damages fails to plead the particulars of the same by mentioning the item or items in their numbers with the cost of each and lead evidence in proof of same to enable the court to calculate what is due to him under the head of the specific or special damages, his claim must fail as the court cannot speculate. See the case of Ukam and Transcorp Metropolitan Hotel and Conference and another citation captured. Union Bank and Innocent Nigeria Limited citation provided. Nwagu and others and Uzoma citation provided. This is fatal to the claim of the claimant. Besides, as reasoned above, claimant has not justified any of his claims above. There is therefore no doubt that claimant's claim on the above must fail in its entirety. Accordingly, Relief B also fails. Claimant by his Relief C is seeking a declaration that except and until the first defendant discharge his self-imposed obligation under the employment contract entered into between claimant and the first defendant, the purported termination of his employment contract between parties cannot be said to be properly and effectively terminated. First, I have found that claimant has not justified the sum claimed in this case. Secondly, assuming claimant even justify the sums claimed, this court will still not have jurisdiction to grant Relief C. That until the first defendant fulfill its obligation under the contract cannot be effectively terminated as it was done in this case after the expiration of the 1-year period. This is because a private limited liability company or any employer of labor, like the first defendant, does not owe any obligation to retain the services of any unwanted employee. Thus, even if the first defendant did not fulfill its obligation under the contract and the employment relationship is terminated upon the expiration of its duration, the employment relationship stands effectively terminated, howbeit, and the court cannot hold that the contract is still subsisting or that same was not effectively terminated. This is born out of the standing principle of labor law that a court cannot impose a willing employee on an unwilling employer. See the cases of Agu and others and Julius Berger Nigeria PLC, citation captured, Abba and Benue Cement Company PLC and another citation provided, ACB Limited and Ufondu, citation captured, UBN and Ubo, citation captured. The moment the 1-year employment contract between parties in Exhibit B expired and was not renewed, the relationship stands terminated automatically, and under no guise will the court have jurisdiction to hold that same is still subsisting or that the contract was not effectively terminated. It is clear from the above reasoning that this court finds that Relief C fails. I will take reliefs D and E together. Relief D seeks for a declaration of this court that claimant is entitled to retain and exercise right of lien over the first defendant, Toyota Camry 2018 with registration number MKA 865ST, assigned to him as his official vehicle until the defendant defray or liquidates its indebtedness to claimant. Relief E, on the other hand, seeks an order restraining the first defendant from using agents of the second defendant from waylaying, harassing, or intimidating the claimant in the bid to stop the claimant from exercising his right of lien on the Toyota Camry car. Claimant in respect of relief E averred that the first defendant is taking steps to use the agent of the second defendant to stop him from exercising his right of lien over the said vehicle. The first defendant vehemently contended these facts in his statement of defense, wherein it averred, by paragraphs 26 and 27 thereof, that apart from its letter of demand written to claimant, it has not taken any steps to recover the vehicle in question, and that claimant ought to return the first defendant property in its possession after the expiration of the contract since February 2022. And despite this, claimant failed to return the said vehicle. I must say that claimant has not even placed any credible, cogent, and compelling evidence, oral or documentary, before this court to link the second defendant with this suit by proving his assertion that the first defendant is taking steps using the agents of the second defendant to stop him from exercising his right of lien over the said vehicle. Be that as it may, there is no doubt that reliefs E and D are equitable reliefs. This court is as much a court of equity as it is a court of law, as I've stated earlier in this judgment. Equity does not act in vain and should not be taken for granted, but it is grounded on solid facts that will induce the court to act in favor of the person seeking the invocation of equitable jurisdiction of the court. See the case of Ritchie and Nigerian Bank for Commerce and Industry citation captured. As between claimant and the first defendant, there are no grounds, legal or factual, shown in this case by claimant for the invocation of equity jurisdiction of this court for the grant of this relief, for equity does not act in vain, as I've stated earlier. Claimant has failed to show that he deserves the relief he seeks in equity. Claimant, in view of all reasons supra in this judgment, has no right to exercise a right of lien over the said Toyota Camry 2018 model with registration number MKA 865ST, which has already been retrieved from him without any objection by his counsel, as stated earlier in this judgment, and already parked in this court premises. The contract between parties has ended since February 2022, and claimant has not justified his claim. The event has actually overtaken this relief. These reliefs, therefore, must fail. Thus, reliefs D and E accordingly fail. I'm, however, mindful of the fact that this court made an order on the 11th of January 2023 that the car in question be deposited in this court premises within 7 days, which was done. The said car since then has remained in the premises of this court since then. The law is settled beyond arguments that a superior court of record like this court, though lacks the power to grant a relief that was not sought, it is, however, endowed with inherent power to make consequential orders, even though not claimed, if it will give effect to the judgment of the court delivered by the court, especially for the purposes of promoting justice in the case. See the case of Helmer and others versus Buba and another citation captured, Idigbe and Inyaji citation captured, Amechi and Inex citation provided. Since reliefs D and E has failed, then it is only expedient that this court makes an order releasing the said car to the first defendant, who has immediate right to possession of the said car. It is in the light of this that this court makes an order that the said Toyota Camry 2018 model with registration number MKA 865ST be forthwith released to the first defendant or its agent upon proper identification. I so order. On issue 2, the law is right that a counterclaim, though related to the principal action, is a separate and independent action because it's a defense which enables the defendant to enforce a claim against the plaintiff or the claimant, as in this case, as effectually as an independent action. See the case of IDAM and NLPC Pension Fund Administrators and another citation captured, Gowan and Ike Ogongu citation provided. The success or otherwise of a counterclaim being an independent action does not depend upon the outcome of the main claim. Each claim must be heard and determined on its merits. Counterclaim is of the same status like the main claim and as such receives the same treatment as the main action. Pleadings are filed
My microphone is unmuted.
Hello, my lord say I should tell you people that it's her network that is having issue, that she'll be connecting back very soon. She's trying to connect it back. It's the network that is having issue there.
He's talking to us that my God said our network is having issue that they are trying to connect back.
Yes.
very clear.
So
I
I
call.
had issues with my network. So thank you for the patience. So I'll continue. The first defendant counterclaim from the claimant the total sum of 6,377,520 naira, representing the outstanding sum due from jobs not carried out by the claimant during the period of his employment. This is no doubt a claim for special damages that is granted only upon strict proof. The first defendant claimant averred that during the subsistence of the employment contract, it paid claimant the sum of 5,500,000 naira for the review of the public-private partnership between it and the Federal Ministry of Water Resources, but claimant failed to deliver on this instruction as he did not review the PPP within the given timeline, which caused a huge embarrassment to the first defendant. Claimant defendant to the counterclaim in his defense, read paragraphs 24 and 25 of his reply to the statement of defense and defense counterclaim, averred that this claim of the first defendant counterclaimant is an afterthought, and that the counterclaimant never rejected the PPP review document when it was submitted, and upon completion of his tenure, sent him a letter wishing him well in his future endeavors. These facts were equally reiterated in the additional written statement on oath of claimant on the 4th of November 2022, which was already adopted as part of his oral evidence in this case. See paragraph 28 of the claimant's additional statement of oath. In fact, claimant additionally stated that he has effectively delivered on the PPP agreement and mode review mandate. The counterclaimant contended the above defense of claimant and averred by paragraphs 2 to 12 of his reply to defense counterclaim, as stated earlier in this judgment, where a party fails to cross-examine a witness on the material point, it means that such a party accepts the truth of the testimony. See Oluwole and Olatunji Supra, Gambo Issa and another Supra. Learned Defense Counsel never cross-examined claimant on this material point, that the claim of the counterclaimant is an afterthought and that the PPP review document was never rejected, in addition to the fact that the counterclaimant did wish him well upon the completion of his tenure, which means that the counterclaimant accepted it. In my view, please mute yourself, Techno Roboy 3+. Mute your phone, mute your system, please. Thank you. In my view, assuming the claim of the counterclaimant is even true, as regards the failure of the claimant defendant to counterclaim on the PPP review document, the first defendant cannot be heard to complain at this stage or claim for money given to claimant for that purpose. In my view, the principle of condonation will come to play, and which literally means to pardon, to overlook as offense, to forgive, or to act so as to imply forgiveness. Thus, condonation is the art of condoning or pardoning a wrong act, the implied forgiving or pardon of an offense by overlooking it. It is obvious that the counterclaimant indeed condoned the alleged misconduct of the claimant by not complaining after he discovered the alleged misconduct, or even gave claimant a letter of well wishes at the completion of his tenure. It cannot shy away from it. There's also waiver by action or representation that can bind the counterclaimant and stop it from raising the same facts that were earlier on overlooked by it. See the case of Benue State University and Mogaji, citation captured. The case of Nigeria Army versus Aminu Kanu, citation provided. The counterclaimant is therefore stopped and cannot be claiming for the money it paid to claimant for the PPP review when it never complained that claimant failed to submit the PPP review document within the timeline instructed. I'm thus in agreement with claimant that the claims of the counterclaimant as to this sum is in the realm of an afterthought. I so find and hold. The counterclaimant also claimed claimed that the claimant was paid the sum of 124,270 naira to produce business cards, ID cards, and lions for management staff, but he neither did it nor refunded the said money. Claimant, in response by paragraphs 26 and 27 of its averment, stated that contrary to the first defendant's counterclaimant claim, The business cards was produced and distributed accordingly, except for that of the management staff due to the fact that the designation of some of the said staff was not confirmed by the board of directors. He further contended that had the cards produced when the final corporate structure was yet to be approved by the board of directors, it would have amounted to wastage. He relied on Exhibit B3. These facts were reiterated in claimant defendant to the counterclaim's additional written statement on oath, already part of claimant's evidence in this case. The counterclaimant viewed paragraphs 14 and 15 of a reply to the counterclaim and contended that claimant has neither produced the ID cards nor refunded the above sum, and that it is not true that its management structure has not been confirmed by the board of directors at that time. It is worthy of note that the counterclaimant, who is the one alleging the positive in this case, is the one who has the burden to prove the above claims. See our Malay and others as Mustafa citation.
Please, my lord, say I should tell you people once again that it is network problem. At any moment from now, it will fix it, please. We have called our computer room already.
Thank you for bearing with the court. Thank you for bearing with the court. I'll go ahead. I had to change to another Wi-Fi. So hopefully this one will work. Let me continue from where I stopped. The claimant was never cross-examined as to these material facts by learned defense counsel. The position of the law is clear that this is a tacit acceptance of the truth of his testimony. The counter-claimant is therefore deemed to have accepted the evidence of a claimant defendant to the counter-claim as true and correct, and the court is well within limits to act on same. It is also part of the claim of the counter-claimant that the claimant was given the sum of 803,520 naira on the above stated date to subscribe for official email account for the managing director and other management staff, but he also failed to carry out the instruction and also failed to refund the said money. Claimant in response, be it paragraph 29 of his reply to the statement of defense and defense to the counterclaim, contended that the payment of 803,520 naira was a refund to him for the 1-year Google subscription. He equally reiterated this fact in his evidence as contained in his additional written statement on oath. The counterclaimant, read paragraph 16 of his reply to the defense counterclaim, averred that claimant failed to deliver on the subscription of the emails as none of his staff utilized any Google subscription done by him, but he failed to refund the said sum. As reason supra, the burden is on the counterclaimant in this case, as it is the one asserting the positive to prove. Claimant was never cross-examined on the material point raised in his testimony that the sum was for a refund to him for 1-year Google subscription indeed is true and correct. Thus, the contention of the first defendant counterclaimant that claimant is indebted to it in the said sum cannot stand, since it has accepted the truth of claimant's testimony that the sum was a refund of money paid to claimant. Okay, Oshe. What a day. I'll go on. This fact was equally contained in claimant's evidence before the court in his additional witness statement. The counterclaimant, read paragraph 17 and 8 of its reply to defense counter on the 25th of March and 7th June 2021, respectively, and both were paid and claimant did not refund the other sum. However, for the obtained time, claimant was never cross-examined on this material point raised by claimant, that he was not aware of any duplicate payment and same was not brought to his notice. By not cross-examining the claimant defendant to the counterclaim on this evidence, the counterclaimant admitted that it had nothing in the evidence to challenge and that the narration of facts by claimant defendant to counterclaim is correct. The legal consequence of not cross-examining the witness evidence of a particular fact has been restated by a long line of decisions as captured earlier in this judgment. Let me say that claimant was not even cross-examined on his testimony as regards the counterclaim of the first defendant at all, which means that the first defendant does not dispute claimant's testimony thereof. The proper course is to challenge the witness while he is in the witness box, or to make it plain to him at that stage that his evidence is not accepted through cross-examination. See the case of Iya and others versus Shinkepe and another citation captured, or folate and the state citation provided. This court can therefore accept the testimony of claimant as regards the above sums claimed in the counterclaim. I bear in mind that when DW1 under cross-examination was asked by learned claimant counsel, and the answer was, I quote, "At the expiration of the claimant's tenure contract with the first defendant, a letter was written to him without any request of any money is owing the first defendant until claimant wrote through his lawyer to make his own request. Will I be correct to say that it is an afterthought?" He answered, "No, it is a response to an ingrate. He left with the company's car for 6 months. He was paid salaries," unquote. It is clear from the above testimony of DW1 under cross-examination that even though he does not agree that it was an afterthought, he confirmed the letter of the first defendant counterclaimant where the sums in the counterclaim were just demanded was written in response to claimant who he termed quote and unquote an ingrate. In fact, Exhibit D7 lends credence to this fact as it is seen therein that these sums were only demanded when the claimant was responding to claimant's letter. Thus, it is clear that the demands of the first defendant for payment of the alleged debt were just made in response to claimant's own. The claims of the first defendant claimant, the claim of the first defendant in the sight of the law, the counterclaimant did not ask for these sums, and even as reason supra in this judgment, even gave claimant a letter of goodwill and wished him well in his endeavors upon the expiration of the terms of the contract by writing him a letter. Thus, I will take that again. The claim of the first defendant in the sight of the law, the counterclaimant did not ask for these sums, and even as reason supra in this judgment, even gave claimant a letter of goodwill and wished him well in his endeavors upon the expiration of the contract, not until claimant wrote his own letter to the first defendant counterclaimant. Thus, the agitation of the first defendant for these sums comes with a firmament of afterthought. The counterclaim of the first defendant counterclaimant for the sum of 6,377,520 naira, representing the outstanding sum due from jobs not carried out by the claimant during the period of his employment, must therefore fail. In view of all the reasoning above, it fails. The first defendant counterclaimant also claimed the sum of 20,000 naira per day for the unlawful detention of first defendant's vehicle. I've earlier in this judgment held that claimant has not justified his retention of the vehicle of the first defendant after the expiration of the contract. I'm aware that unlawful detention of properties may constitute breach of a person's right to own properties under Section 44 of the Constitution. See the case of Honorable Commissioner for Works, Plateau State and Others versus Inyanja, citation captured. The case of Government of Plateau State and Others versus Nwad Korea, citation provided. However, I bear in mind that the first defendant did not plead in its counterclaim, which is before this court, how it came by the sum of 20,000 naira claimed per day, and the number of days the vehicle spent in claimant's possession, especially before it was ordered to be brought to court, to this court premises for the court to be assessed parameters for his claim. There's no doubt that same must fail for insufficient particulars and credible evidence. It is in the light of this that I also find that the second claim in the counterclaim fails. For the avoidance of doubt, and for all the reasons given, I declare an order as follows. 1, that claimant's claim fails in its entirety. 2, the counterclaim equally fails 3, that the vehicle Toyota Camry 2018 model with registration number MKA 865ST, which is in the premises of this court, be released forthwith to the first defendant counterclaimant's agent upon proper identification. I make no order as to cost. Judgment is accordingly entered. Parties are entitled to have clean copies of the judgment, which they can pick up tomorrow. Very well. Call the next case. Court registrar. Unmute your phone. Is the court registrar online?
Yes, my lord.
Very well. Call the next case. Go ahead and call the case, court registrar. Unmute your phone.
Case number NICN/ABJ/341/2023 between Comrade Stanley Osunday, 2, Comrade David Ishaku, 3, Comrade Bright Usia, and the Incorporated Trustee of Filter Senior Staff Association of Nigeria, 2, Comrade Morista Idibra, 3, Comrade Abinsowe, A. Abinsowe.
Who is in court?
May it please, the Honorable Court. C.A. Ago.
Is there any of the parties in court?
None, my lord.
No, my lord.
Appearance.
May it please, the Honorable Court.
I cannot see your face. If you are the one using Techno Roboy 3+, I can't see you.
My lord, the present.
Go ahead.
C.A. Ago. Ago is A.G.U., my lord.
Oh.
My lord, I humbly appear for the applicants.
Very well. Go ahead.
Yes. My lord, we have a motion ex parte before the court, my lord. My lord, the ex parte motion is filed on the 22nd November 2023.
November.
Yes, my lord. Yes. If my lord permits us, my lord, we are ready to move.
Go ahead.
Yes. My lord, the motion praised the court for 5 reliefs as stated in the face of the motion paper. My lord, the motion is in 2 parts. First part prays for an interim injunction, and the second part is for an order for substitute service. And the motion is supported by 25 paragraphs affidavit. And attached to the 25 paragraphs affidavit is 5 exhibits marked exhibit A to E. Accompanying the said application is 12 paragraphs affidavit of urgency. And also, we have a written address of counsel accompanying the said application.
Very well.
Yes, my lord, we humbly adopt the said written address as our argument. And we humbly pray the Honorable Court to grant the reliefs as prayed. And all the essence of this application is for parties to maintain status quo, pending the hearing of the motion on notice, which is also filed before this court.
Please mute your phone. Mute your phone.
As court pleases. Oh, may you please, Advocate C.A. Ago.
Court registrar, what date? What date?
17th January.
Registrar.
Yes, my lord. 17th January.
I've heard learned counsel and I've perused the motion before the court, and it is primarily seeking for an interim order restraining the respondents. It is apparent on the affidavit file that there is no extreme urgency requiring the order of this court. There's no evidence to show that if this application is not granted within the interim, which can only last for 7 days, the rest will suffer. It is in the spirit of fair hearing, which is entrenched in the order altering pattern rule, that I refuse this application and urge the applicant to serve the motion on notice on the respondents, just so that the court can hear their own side of the story. Consequently, the motion on notice are to be served on all the respondents. The first respondent is to be served by substituted means by pasting same at the headquarters, while the second and third defendant respondents are to be personally served. Cases adjourned to 17/1/2023 for hearing of the motion on notice. Very well. Any other matter?
Me, my lord.
Very well, I rise.
Court.